Claimants who have filed a CA1 for traumatic injuries or a CA2 for occupational disease, and the claims have been accepted by OWCP, the claimants are then entitled to certain benefits. Some of these benefits are listed here, and they include, number one, medical care payments, doctor bills, hospital bills, prescription reimbursement, also reimbursement for any prosthetic devices to help facilitate the healing process for the injured employee. Another benefit is monetary compensation for those employees who are temporarily or totally disabled as a result of the illness or injury and thus are unable to work at all. This benefit is paid only after the claimant or injured or ill employee has lost pay from the agency as a result of their disability. It is important to note that the claimant is only eligible if the medical evidence in the case demonstrates that the employee is disabled. If the injured employee is married or if they have children, they would be entitled to receive 75% of their salary. If the injured employee is single, they would receive 66 2/3 rate of their salary. Know that monetary compensation from the Department of Labor is tax-free. A third benefit, loss of wage earning capacity. This is an adjustment payment to employees who can never return to their regular jobs as a result of their illness or injury, but they can return to a lower paying job. The LWEC, or loss of wage earning capacity adjustment, helps to make up the difference between the claimant's earnings at the time of injury or illness and the claimant's current earnings in the lower paying job. A fourth benefit is known as Schedule Award. These are fixed amounts that are paid to employees who lose specific body parts, such as fingers, legs, and toes, for example, or who are permanently have lost some functioning in a covered body part. Under the FECA, there are 3 parts of the body that are excluded from the Schedule Award provision. They are the back, the head, and the heart. A fifth benefit, known as death benefits. The survivors of federal employees whose death is work-related are entitled to benefits in the form of compensation payments, as well as funeral expenses and transportation expenses for the remains if necessary. A sixth benefit is known as vocational rehabilitation. These are services that are designed to prepare employees who cannot return to their regular jobs for new employment. When the evidence shows that the claim did not meet one of the 5 requirements or conditions of coverage, what hope is there for the employee? Well, whenever OWCP issues an adverse decision about entitlement, such as a denial of the initial claim or denial of continuing benefits, a description and an explanation of appeal rights will accompany that formal decision. Therefore, the employee is given the opportunity to exercise one of the 3 appeal rights. However, an employee can only request one form of appeal at a time. The conclusion of this presentation will focus briefly on the 3 kinds of appeal rights. The first one is known as a hearing. The employee has the option of either an oral hearing before an OWCP representative or a review of the written record. In order to use this form of appeal, the employee would have to make a written request within 30 days of the formal decision, and the employee could not have previously requested a reconsideration or another form of appeal. The request is then sent to the Branch of Hearings and Review at the Department of Labor at the address stipulated in the appeal rights. If an oral hearing is requested, it will be held within 100 miles of the employee's home, and the employee may present written evidence or oral testimony to support his case. However, if the employee chooses a review of the written record, the employee cannot present oral testimony, but is only eligible to submit written evidence. If the employee requests an oral hearing, OWCP will inform CBP, the employing agency, of the date and time. Though the agency may send a representative, that person cannot participate in the proceedings unless he or she was specifically invited to do so by either the employee or the OWCP hearing representative. After the oral hearing is held or the review of the written record has been completed, OWCP will issue a formal decision in conjunction with a description of further appeal rights. A second form of appeal right is referred to as a reconsideration. In order to utilize this form of appeal, the employee has 1 year from the date that the formal adverse decision was issued in order to request a reconsideration. There is no special form required, only a simple narrative statement requesting a reconsideration along with any relevant evidence not previously submitted. The third kind of appeal available to an employee is a request for review by the Employees' Compensation Appeal Board, also known as ECAB. This is the highest authority in federal workers' compensation claims, which is synonymous to the Supreme Court. The employee would file for such review directly with the ECAB at the address stipulated in the formal denial decision letter. When requesting a review by ECAB, no new evidence can be submitted. ECAB's review is based solely on the case file record at the time of the formal decision. For those employees who reside in the United States and Canada, they must file for review within 90 days of the date of decision. Employees residing elsewhere must file within 180 days of the date of decision.